On my agenda, so I'm going to pivot right now to the meat of our presentation. I know you all are really interested in hearing about all of this. We'll start out with Alys Cohen, who's a senior attorney at National Consumer Law Center. Chi Wu, who was a senior attorney at National Consumer Law Center, will follow her. And Lisa Sitkin, who's a supervising attorney at National Housing Law Project, will wrap it all up for us. So with that, I'm going to go ahead and hand it over to Alys.
Well, first of all, thank you so much for having me today. We work very closely with the National Housing Resource Center and know the importance of housing counseling in the community that supports homeowners. I'm going to do a few things in my overview of what's going on with the CFPB. I'm going to talk about some of the guidance documents that were recently withdrawn and why that doesn't really matter, but just so you have a sense of what they're trying to do and then why we don't think they really accomplished a lot by doing that. And then I'm going to talk after that about the CFPB litigation to which we are a party. And we're one of the institutional plaintiffs in that case, organizational plaintiffs. And then I'm going to talk about something that's coming where we're going to ask for your help in defending some rules that the Bureau we expect is going to try to get rid of. And then I'm going to talk about some non-CFPB Washington related housing issues. So the first thing that I wanted to talk about, and I think there's a slide, here it is now. So a lot of this information is available in the slides that are in these links that are here, the first two links, but I'm going to go over some big ones. So essentially, the CFPB withdrew over 60 guidance documents that had been issued in prior administrations. And they did that without saying these rules are no longer good as we describe them. Instead, they actually said the opposite, which was we're not rejecting the content of these guidances, but instead we're just not going to use them for our own enforcement. And so what that means is that the justifications that they gave for withdrawing the guidances don't really go to the merits or the content for any of the individual rules. And so what's the practical effect? The practical effect is that the laws that we all rely on to protect homeowners, like the Truth in Lending Act and the Real Estate Settlement Procedures Act, and the ways in which those rules are implemented and understood don't change. And moreover, to the extent that guidances are helpful in understanding the nuances of how the rules work, they can easily be restored by a future director without going through a whole rulemaking. So guidances are kind of a double-edged sword. They're very helpful, but they're also not the same as having something with the force of law. They essentially provide advice for people who work with homeowners and also for companies to understand how the rules work. And so the fact that the document has been withdrawn doesn't change the content of the guidance, which has analysis about why certain understandings about the rules should reign. And so when it was initially issued, each of those guidances interpreted regulations and described why these understandings about them applied. And so these understandings will still be things that lawyers can use in helping homeowners save their homes and that you can also rely on. So now I'm going to talk about a few of the guidances. So the first one that I wanted to talk about is something that relates to the Truth in Lending Act. And so as you all know, when someone takes out a mortgage, lenders, after the Dodd-Frank Act was passed in 2010, lenders are obligated to ensure that homeowners have an ability to repay the loan that they're getting. And then when the mortgage servicing rules were passed or were issued by the Bureau in 2015, They also started to include special protections for successors in interest, people who acquired title to a dwelling, but were not necessarily originally on the loan or the note. And so there's a process sometimes where that successor, it could be someone who got the home in a divorce, or it could be the widow, or it could be another family member for another reason. Sometimes they want to get themselves added onto the note because it just makes things easier. So they're added as an obligor, as it's known. And so the Bureau put out a guidance making clear that when someone gets put on a note as a successor, that they don't have to qualify for ability to repay the same way they would if they were taking out a new loan, either to buy a home or to refinance, etc. And that's because they're already on title to the home and they've already been part of the household that's making the payments. And so it's still true that if you're helping someone get a loan modification and they choose to get added to the loan, that they should not be evaluated for ability to repay. And we don't frankly expect that companies would start to do that. So another bulletin that had come out in 2021 was about RESPA, the Real Estate Settlement Procedures Act. And this really, we think, has no meaning, and the fact that it was withdrawn is confusing at best. It was about oversight that the Bureau was doing during COVID and how they were going to do more oversight to make sure that servicers were properly managing requests from borrowers for assistance. And so they withdrew that, but it's really not timely anymore. And as you'll hear in a few moments, they're not really doing any oversight anyway. And so this is just another confirmation that they're not doing their job. Now, there were several guidances under the Equal Credit Opportunity Act. That's the law that prohibits credit discrimination, that were also withdrawn. These are on really hot button important issues. But as I said before, the fact that the guidances are withdrawn doesn't change the fact that the underlying laws and the underlying analysis from the original guidance still apply. So the first one I want to talk about was a guidance that was put out in 2021. And these are all available. This whole set of rules and our article about it are available sort of in two different forms in the links that are on the page here that you'll have access to. So the first guidance I wanted to talk about is an understanding of what it means to be a victim of sex discrimination in the credit market. And the Bureau had put out guidance saying that sex discrimination includes sexual orientation discrimination and gender identity discrimination. And this is not something that's unique to this guidance. There have been a lot of legal decisions about this at various levels in the courts, and there have been a lot of other moves in this direction. And whether or not the Bureau acknowledges that sexual orientation discrimination and gender identity discrimination are sex discrimination, that is still law in many places, including the Supreme Court last time I checked. So that's the first one. The second one I wanted to talk about is a guidance that was issued in 2022 about what is the scope of the protections for credit discrimination. And the innovative thing about the Equal Credit Opportunity Act, which has been around for decades, is that it doesn't just protect you in your actual loan application when you're applying for credit. It also protects you in the process leading up to that application, and also once you have the credit. And that's clear in the regulations, it's clear in court decisions. And they had also put out this clarification in 2022 saying that if you're seeking credit or if you've received credit, not just in the actual application, but in these other two before and after stages, that you're also protected from discrimination. And even though the Bureau has withdrawn their use of that guidance, the guidance is still useful and the law still stands as it is. And so your clients are protected from discrimination throughout the credit process. The next one I want to talk about is about adverse action notices. That's essentially when the applicant is notified that they either weren't receiving credit or weren't getting the credit they had asked for and were being offered something else. And the reasons for that adverse action are required to be included in that notice. And this guidance says, even if a complex algorithm was used, you still have to give the reasons. You can't just say, oh, it was a black box, we don't understand it, sorry. And so even though this guidance was withdrawn, companies are still obligated to provide that information and the reasoning is still good. And lastly, you all may have heard that this administration and many previous administrations have sought to change how we understand the scope of what is defined as discrimination. And the guidance that was put out in 2012 by the Bureau shortly after it was established said that discrimination includes disparate impact, meaning you don't have to prove that they did it explicitly. If the policy has a disparate impact on protected groups, then those people are protected by the discrimination laws. And that understanding of the law still stands today until we are told otherwise. So those are just those guidances, but what you really need to know overall is the rules and the processes that you've been using to help your clients, they still apply and they still help your clients and you can still rely on them. And if that changes, we'll let you know because there's a lot going on in Washington and I'm going to talk about a couple of those things now. So one thing is the CFPB that's been issuing these guidances and these regulations and doing oversight of mortgage companies and many other types of companies. The CFPB itself is in danger, and the Trump administration has been seeking to dismantle the agency. And so NCLC joined with the NAACP and other groups and individuals and the union of the CFPB employees to sue the administration to stop the dismantling of the agency. And on March 28th of this year, the district court judge issued a 112-page opinion issuing a preliminary injunction, and that's here at the bottom of your screen. It's a good read if you have spare time to read 112 pages, but this is a brief article that gives you some overview about it. And essentially, it's stopping the Bureau from being dismantled, from people being fired, from more actions being taken to stop the work of the Bureau. For example, contracts they have with different kind of contractors on the complaint system and on other things. And so that's the good news. The bad news is that the CFPB in its current incarnation appealed that. And there's been a lot of back and forth and a lot of steps, but essentially right now where we are is the appeals court is considering whether to uphold this preliminary injunction that is stopping the Bureau from firing most of its employees. They've already fired a bunch already, but this would allow them to fire almost everybody and cancel most of their contracts. And so the question is whether the appeals court will uphold the preliminary injunction or not, or do something else. They have already indicated to some extent, the appeals court, that they want a real deliberative process in making these decisions. And the question remains whether the court feels that they can look behind the decisions when the CFPB says, oh yeah, we're firing 1,000 people. We did that over the course of just several days. And yeah, we made deliberate decisions about each of these categories of people. So before I go on to a couple more brief points and then turn it over to my colleagues, I wanted to share with you, this is the 112-page decision. I wanted to share with you a couple of things because I want you to know that even though things are hard here, people are fighting back with everything they have. Chi-Chi's been involved in a bunch of that on some other fronts, among many other people. And we have the best litigators in the country working on these issues and really trying to make a difference for all of our clients and for all of us and for, the people in this country who need the protections of the CFPB. So the judge's decision stopping the Bureau from firing almost everybody and canceling almost everything starts with 3 quotations. One from Elon Musk, and at the end she says, no, you can't do any of that. One is Elon Musk's tweet from February that says CFPB RIP. One is from Russell Vogt, who is running the Office of Management and Budget, but he's really also the acting director of the CFPB right now. And his quote is, the CFPB has been a woke and weaponized agency against disfavored industries and individuals for a long time. This must end. And then the last one is a statement from President Trump from February 10th, quote, that was a very important thing to get rid of, end quote. And so the judge's point is, and she goes on in this fabulous document, describing how even though the government says they're not really trying to get rid of the agency and they're just trying to make it more efficient, that in fact, they're not doing that. And I think sharing these quotes is her trying to explain that that's true. And so I'm just going to read you a couple of short quotes from this document. One is, the stop work order stopped all work, including statutorily mandated work, and the flurry of emails circulated on the eve of the hearing on the motion were little more than a transparent effort to pretend otherwise. And as the documents and witnesses' testimony revealed, there was little or no analysis undertaken before the employees were told to put their pencils down, before all of the agency's contracts were canceled, etc. So that's one thing I wanted to share. And the reason I wanted to share it is, yeah, they're doing bad stuff, but the judge is memorializing all of that, and she's pushing back. And then she concludes by saying, plaintiffs in this case will face irreparable harm without preliminary relief. This is why she's providing the preliminary injunction. The shutdown will take little more than a month, if that. The record reflects that the reduction in force notices giving employees 30 days notice are ready and waiting. The decision to place employees on administrative leave during those 30 days has been made with the understanding that they can be called back not to serve consumers, but to fulfill closeout duties. The CFPB building is already closed. Arrangements to cancel the lease and move out in 30 days were made 5 weeks ago, and this is from the end of March. And the technology to work remotely has been canceled. Once the agency is gone, there will be no opportunity to afford relief at a later point in the litigation. So we're waiting to hear from the court. We're doing everything we can, all of us, and we'll keep you posted. But we're all here, and we're still going to be working with our clients, and we're still going to be working in states, no matter what happens. Now, here's something else that the CFPB is trying to do with the few people who are working over there. Many of you help clients apply for loan modifications with a mortgage servicer. In order to do that in the best possible fashion, you're relying on rules under the Real Estate Settlement Procedures Act called RESPA. And the regulation is called Regulation X. All the regulations have letters. The Truth in Lending Act is Regulation C. So the CFPB issued rules and updated them many times, saying that if your client applies for a loan modification, they can't be put through foreclosure. If there's an error, they can submit a notice of error. If you submit for a request before a certain number of days before your foreclosure, that foreclosure has to be halted until the evaluation is over for the loss mitigation, etc. The CFPB is going to issue what's called an ANPR, an Advanced Notice of Proposed Rulemaking, which is mostly, we're planning to do a rulemaking, here are some questions, and they're planning to repeal all or most of those rules. Also rules about how you can get information about who the servicer is and other things like that. So when that Advanced Notice of Proposed Rulemaking comes out with those questions, including questions like, well, how would it be if we just canceled the whole rule? We are going to reach out to all of you and ask you to submit comments. But instead of just submitting comments about how that would be bad, what we really want people to focus on is what it was like before the rules existed. Many people remember what it was like during the financial crisis when we didn't have one set of procedural rules. And it was very, very hard to get a homeowner to the finish line just to submit a request for assistance. I will also tell you that in that same round of rules that are in the making, there's also one to withdraw the rule related to paying mortgage brokers more to give people bad loans, the loan originator compensation rule. And even the bankers told me earlier today that they need that rule because there are a lot of important clarifications for them. They also want this rule to stay. We all think it needs to be updated. So we're going to be doing everything we can, and industry is going to be doing everything they can to see what we can do, but we're going to ask for your help, and we'll keep you posted on that. Lastly, I just wanted to tell you about what's going on at a few other government agencies. There's a letter here that our coalition sent on May 15th to the Federal Housing Finance Agency. That's the agency that oversees Fannie Mae and Freddie Mac. And also to HUD, which does FHA loans, saying that a bunch of their policy changes are going to make it worse for homeowners. So for Fannie Mae and Freddie Mac, they've canceled a lot of the oversight about unfair practices, about helping people get into mortgage loans if they come from underserved communities through special purpose credit programs. They've stopped the whole program to look at equity in both making of mortgages and the servicing of mortgages through the equitable housing finance plans. But there are still some statutory rules that apply. They're called duty to serve and the housing goals. And as everyone in Washington talks about turning Fannie and Freddie private, there is a strong coalition of people who are defending the need to make sure that Fannie and Freddie reach, and frankly, reach better into low-income communities, communities of color, underserved communities, rural communities. I want you to know that the CFPB complaint system is still up and running, and the HUD National Servicing Center is still up and running, relatively speaking. And it's still important for you to submit complaints to those places so that they know that we need them. We recently learned that there are not going to be a ton more firings at HUD, but they are cutting back on a lot of funding. As you heard, housing counseling may be one of those, disaster relief may be one of those. But we have to still be looking at what we can do with these agencies and at the same time pivot to the states. And we encourage you to file complaints with your state bank regulator, with your state AG. Lisa's going to talk more about logistics later. And so finally, I just want to point out that if you work with clients who have VA loans or USDA loans, it's very hard to get an affordable loan modification right now because they just canceled the only workable program called the VASP program for VA borrowers, and we're working on a replacement for that. If you find that you have clients with VA mortgages and they're not able to get affordable loan modifications, please get in touch with us because we're trying to keep track of what's happening. I would also encourage you to contact the US Senator for the state where that person lives. So finally, I just want to remind you, your advocacy is really important, and it'll be more important as they try to take away our rules, but also at the state level to make rules better and to make sure that your clients can get the extra assistance that they need. Thank you so much.
Go ahead, Chi.
Okay, thanks, Alys. Thanks, Ellie. Thanks for that terrific presentation. So as Alys said, the CFPB's Consumer Response Unit is still up and running. They are still accepting complaints. In fact, they just issued their annual report about complaints last month and found that the number of complaints to CFPB in 2024 increased, including credit reporting complaints. As some of you know, credit reporting complaints by far are the hugest category of complaints to CFPB, 85%. And last year, there were 2.7 million of them. That's a lot. And so from what I understand, housing counselors were among the group of folks helping consumers file complaints with CFPB on credit reporting disputes. And that was a real tool to help your clients deal with credit reporting inaccuracies. And I was asked to talk about, well, with the CFPB hampered and everything going on, what now? How to help your clients with credit reporting inaccuracies now that the CFPB is in turmoil. So first of all, I want to say that the fact that housing counselors were getting results by sending complaints to CFPB was fabulous. As you can imagine, with 2.7 million complaints to CFPB on credit reporting inaccuracies, even when they were fully staffed up under the last administration, they weren't dealing with all of them. So the fact that the complaints that you guys submitted were getting attention was a testament to how amazingly effective you are. I've actually had private practitioners who've said, oh yeah, my clients try filing complaints with CFPB, but that really didn't do anything. So the fact that it was an effective tool for you guys is great, and it is a loss not to be there. But what that also points out is that for folks who weren't able to get relief through the CFPB consumer response, there are other avenues available. The Fair Credit Reporting Act, which governs credit reporting and other type of consumer reporting companies like tenant screening, it has a fair number of self-help remedies. It was the first line of defense to credit reporting and other types of consumer reporting inaccuracies is the right to dispute errors in your credit report or consumer report. And that always is the first step when you're trying to help a client with a credit reporting inaccuracy, is to put together a good dispute letter. Because theoretically under the statute, that's actually supposed to work and get it fixed. Now we know oftentimes it doesn't, and you're going to have to go further than that. But that's the first step, and it's incredibly important to write a good dispute letter. I'm preaching to the choir, right? You guys know this. You have to lay out that dispute in a letter in detail with attachments and send that dispute in writing to both the credit bureau and the creditor or debt collector that furnished or provided the information. And why in paper? Because that's how you establish a paper trail for potential litigation. And frankly, we know paper disputes by mail are more effective. They actually pay more attention to those. And a well-written dispute you can use for many purposes. So that can be the same dispute you send to the CFPB, if nothing else, for record-keeping purposes and to establish, yes, credit reporting errors are still a huge, massive problem in this country. You can send that to some of the other avenues I'm going to talk about, such as state AGs. And if it gets to the point of private litigation, that dispute is going to be a key point of evidence. So well-written dispute, super important. There's advice from NCLC on how to dispute errors in a credit report. We don't have a sample letter in our advice piece. There are sample letters. Here's a post link to an FTC one. That particular one is to the business that supplied the information or the furnisher. Remember, a copy of the dispute should always be sent to the credit bureaus, because under the Fair Credit Reporting Act, the only way to preserve a legal remedy against a creditor or debt collector that provided the information, the furnisher, is to send a dispute to the credit bureau. It's a little wonky and a little wacky. That's just how the law works. But if the client wants to be able to sue the furnisher down the road, they have to send the dispute to the credit bureau. The reason our advice to consumers doesn't have a form letter is because there is some downside of using a form letter. So with 2.7 million complaints to the CFPB and tens of millions of disputes every year, it's a lot. And the credit bureaus, unfortunately, part of the reason why sending a dispute often doesn't work is they've automated the heck out of the system so they don't have to spend a lot of resources in dealing with it. And one of the biggest things their systems are designed to do is to screen out credit repair. The credit bureaus love to claim that these millions of disputes are from credit repair. I don't think so. A lot of people don't think so, but the credit repair does exist. And so what the credit bureaus are more concerned about or concerned with or trying to do to keep their bottom line is they try to screen out credit repair, and they do it very aggressively, over aggressively, and in fact basically throw the baby out with the bathwater. So they'll often say something is from credit repair when it's not. And one of the biggest indicia that they use that something's credit repair is language that they see in a whole bunch of different disputes. So that includes form letters. In fact, the CFPB in 2022 put out a report saying the credit bureaus are, inappropriately screening out and treating as credit repair all these disputes, including ones that use the CFPB's very own sample letter. So, and the CFPB said, yeah, no, credit bureaus, you're not supposed to screen out letters just because maybe they use some language from a form letter if it's otherwise individualized. So they did get better about that, but I expect a lot of backsliding to happen without an effective CFPB. So bottom line, write a good dispute letter, be careful using form letters, send it by mail. Next slide. So you do all of that. Next slide, please. And then what happens? The error doesn't come off. What do you do? Okay, so this is where you usually would have sent the complaint to the CFPB. Still send it. We need it for data and record keeping purposes, but also send it to your state attorney general. State attorneys general have the authority to enforce the Fair Credit Reporting Act under that law. So your state AG can be a source of help. Your local consumer program can be a source of help. And then the Fair Credit Reporting Act, again, was designed to be a self-help statute, and push comes to shove, you may have to help your client find a lawyer. If they have an especially egregious error, a very strong case, they may be able to find an attorney. And the best place to look for one is the website of the National Association of Consumer Advocates, which is a trade group for plaintiffs or consumer-sided attorneys, a lot of whom have experience with the Fair Credit Reporting Act, because it is a kind of a technical statute with a lot of pitfalls. So you could try that. You could try legal services. Some legal services do deal with credit reporting disputes. So those are all avenues of potential relief. Thank you.
And with that, we'll move to Lisa Sitkin.
Hello. Good morning, good afternoon. I know we're spread all over the country. I'm in California. I wanted to take my time here to talk not so much about the detail of what's happening and not happening, as Chi-Chi and Alys have, but to dig in a little bit more on what do we do, regardless of what's happening with the rules and with the agency and who's there and who's not. You all have clients coming in the door or calling you or meeting with you on Zoom or whatever platform, and you need to figure out, how you can help them. The bottom line thing I would say is the tools that you have and the way to approach clients' issues really have not changed. The rules really do remain the same, but also just the procedures and the protocols and, you know, how we go about doing this work. And I'm talking my work, for those of you who know me, is primarily on home ownership preservation for low and moderate income homeowners. So that's sort of what my focus is, but this applies as well. I mean, Chi-Chi just gave you some really good tips about the credit side of things, which I know is relevant to all of this too. So I just wanted to go through some things that may feel sort of like review to you, but just to kind of bolster our sense that we should continue to do the work we've been doing in a lot of the ways we've been doing it, and a couple of tweaks here and there, but that's what I'm sort of here to champion. So the first thing is, please do continue to make CFPB complaints. We know everything is in turmoil. There are huge question marks about who's going to be there receiving them. It is a statutorily required, a legally required function of the agency that they receive complaints from consumers. What they do with them, what happens at the back end, there are some things they have to do with them, but some places where there's more discretion. And I would expect, I haven't lately followed a complaint through in the past several weeks, but some of you may have. What I would expect is that where maybe we used to send in a complaint that said, you know, I've applied for a loan modification on an FHA loan. They're not following the FHA waterfall. They're not doing any of the things. They just denied them for the wrong reasons. In the past, while the CFPB was not in the business of like resolving complaints, and sometimes that didn't get us very far, what we could often rely on was that at a minimum, the CFPB would turn to that servicer and require them to respond both to the CFPB and to your client. And in doing that, often we ended up getting the attention of a different department at the servicer, because often it was like their government affairs department. And sometimes that actually yielded better results when we were kind of hitting a brick wall trying to escalate things at the servicer or even through the National Servicing Center, which also we should use. So I don't know that that's going to be the story now. It feels as if the motivation, let's say, on the side of the agency and the people running it now to actually try to help people is very low. Their attention seems to be more on dismantling what has been built. But it is still important to file these complaints. And the reason is that and I know Alys and Chi-Chi, if she's still here, and Ellie and Bruce, we still have faith that regardless of what is being done to this agency now, unless and until Congress actually, you know, changes the law, making this a required function of the federal government, there will be at least a holding place for this agency to come back to life in the future. And at that time, we don't really want for there to be several years where there's just sort of a blank and no complaints, and that people who are still resisting, you know, let's say someone who actually wants to revive the agency comes into running an administration, we don't want for the opposition at that point to be able to say, well, everybody's fine, like the states are taking care of people or they're not having problems because we don't see any complaints. It really is important to make a record. I've been talking about it to myself and others I work with as like, we are all here right now to bear witness, right? We are all here to tell the story of what's actually going on to people. And that really matters. even if it can feel very frustrating to send a complaint into what feels like kind of a black hole, and it may feel like that for a while, it still matters to make that record and to have it be there for when we need it so we can bring things back to where they should be. So I know it can take time, but it really is important. So I just want to encourage you to do that with the understanding that that's probably not going to be your path to resolution, but that you are contributing to the larger work of keeping this function alive and keeping the possibility of bringing it back to where it's been in the future. While the CFPB is, let's say, hibernating, making complaints to your state and local regulators is more important than ever and is probably the more likely way of getting someone's attention, of shaking loose a real response, a substantive response from a servicer. So we've provided here, and I know you have access to these slides, how to find your state regulators. And there's a specific site for state attorneys general. Different states are set up differently the way that they take consumer complaints. So here in California, it's the Department of Financial Protection and Innovation, DFPI. That's the one I know best. In other places, the Attorney General's office may be taking the complaints, or there may be special consumer protection agencies. But you do want to get familiar in the state or states where you are serving people with which state agencies and local, if you have some places local do have these protections, like LA, I know, has a whole consumer affairs department. Get familiar with who's in charge of mortgage servicers, who is minding the store. And find out how you can make complaints to them, what the process is, and have that be part of your normal protocol when you're trying to resolve an issue that you haven't been able to resolve through the servicer, or if it's federally backed, through a particular agency escalation path. So I would put that on high on your to-do list to make sure that you're clear about where those complaints can go and how to submit them and how to put them together. We at NHLP are always happy to offer technical assistance. If anybody wants to contact me, or I also work with Stacy Tutt, if you know her, with help just looking over a complaint or something like that, with help figuring out what agency you should be looking to if that's not clear. Feel free to get in touch. It's always useful information for us to learn about what you're working on and what questions you have. So happy to make ourselves available for that. The other tool, which I'm sure many of you are already familiar with, is the used to be more broadly referred to as Qualified Written Request, or QWR. When the CFPB came into being and made some kind of rules under the bigger statutes, they broke those into two categories called requests for information. You'll often see those referred to as RFIs, and notices of error, NOE. And all this is basically a tool that borrowers and advocates for borrowers, as long as they are authorized in writing by the borrower, can use to get information from servicers about the servicing of that person's mortgage account, and or to notify the servicer that an error has been made, something has been misapplied, you believe that something is wrong with the escrow account, whatever the nature of the error. There are many, as we know, that get made. And you can, I mean, these letters, there's no set form for them. I know NCLC, and I should have actually, maybe we can add this link that we send out to people, but NCLC has some good templates that can be used for these letters. But again, these are things that don't have necessarily a particular form they have to be written in, but they do have to clearly state, you know, what specific information is being sought, or what the actual error is and what you're asking to be done. And again, borrowers can submit these themselves. You can submit them on their behalf. An attorney who you refer to or work with can help in the drafting, in the sending, if they are willing. So there are lots of ways it can be done, but the key thing, just the really important technical point, is when you are using this tool, they have to be sent to a very specific address at the servicer. The servicer is supposed to make that address clear on mortgage statements, on their website. It should not be, you know, a game of hide and seek. But I find that they sometimes use different terminology. Often it's like, so it won't necessarily say, here's where you send requests for information or notices of error or qualified written requests. They'll say correspondence or something. So sometimes you have to dig a little, but there are, and Ellie, I don't know if you guys have a kind of live list of QWR addresses that you guys keep for people as a resource, but that might be something that would be useful to have. I know sometimes they float around on some of the listservs that I'm on.
We do
Anyway,
not. We do
okay.
not.
They should basically stay the same, but you know, there's a lot of consolidation and different stuff in this industry, so things do change. So if you are working on one of these, it's always good practice to just double check on the website or on, you know, the bottom or the back of the mortgage statement to make sure that you're sending it to the right address. The reason is that as long as it's sent to that address, the servicer then has a legal obligation to respond, to actually give a response within a certain amount of time. Initially, it's like 30 business days, although sometimes they will write and say we need more time, which is very annoying to me. But that's the kind of baseline. And they are supposed to actually acknowledge them within 5 business days, I believe, of receipt. So there's a legal process that you're initiating when these letters go to that correct address. And if they don't respond or respond completely insufficiently, that actually sets up a legal claim that a borrower might have. Obviously, you guys are not going to be managing the legal claims, but it does give leverage to a borrower who might then go to legal services, go to one of those National Association of Consumer Attorneys listed attorneys for help, and they will have that as kind of the background of their case. That will be a legal claim that can either be used in court or used as leverage in some kind of negotiation. And that brings me to partnering with legal services, community groups, and public officials. Now more than ever, it's always been important to have relationships with these 3 groups and to use them. But this is a time when, in many, many ways, we need to partner and collaborate and join in community to take care of each other. And making sure that your organization has robust relationships with legal services agencies in the relevant service areas is really, really important. As those of you who may be in California know, that's been one of my sort of projects over the last many years, is to create more of a sense of a network of housing counselors and legal services attorneys. But having that as a resource where you can ask questions, where you can refer people, where they can refer to you, where you know what each other does, is really, really important. And as you get into issues that may, actually trigger legal protections or legal violations or things, you want to have that resource for your clients, for somebody to give things a look from the perspective of what's going on here legally. So I just cannot emphasize enough how important that is. Obviously, working with community groups to educate folks and have outreach in your communities is really important, but also important because they may be needed to, motivate and activate to put pressure on, let's say some agency that might be able to step in and do something. And public officials at all levels of government can be useful in, they have constituent services usually, and they may be able to reach out to resources that you may not know about or have, or they may be able to, get involved directly in a given situation. So cultivating those relationships and utilizing them is really, really important. I know there's a link here where you can share client stories. I know we're asking a lot of you in terms of, submitting CFPB complaints, even though it may feel like it's going into a void. And please give all your client stories. This is crucial part of the work we are all doing. And I cannot emphasize enough how meaningful it is for those of us who are working directly with folks who are being impacted by a lot of the changes happening, but also just on a day-to-day basis by what a servicer does or doesn't do, or what they screw up or what they neglect. Part of our role is, as I said earlier, to bear witness, right? Always, but more so right now. It's really important for all of us to think of our role as keeping track, right? Of not just feeling like, oh, I mean, I feel like this every day, but this is very overwhelming, so much change, so much noise. But one thing that we can do that I absolutely guarantee you is meaningful is help have a repository of information, of stories, um, of, witness accounts, let's say, of the testimony of people who are living their lives and being impacted by everything that's going on. And in this area where we work, let's say, just helping someone keep their house or avoid foreclosure, which is not just, it really matters to keep those stories alive and keep them in a place where they can be used and organized and made purposeful for advocacy now and in the future. So I know we're all busy, but this is really part of the work. And so I would really ask you to make time as much as you can to share client stories. And it doesn't mean that you have to like write a several page essay about anything. It really is like, I heard this week, for example, we have someone at a legal aid agency, they're trying to contact this one servicer and there's no one ever picking up. There's only a voicemail that says, we'll call you back within 24 to 48 hours, and then they don't. We've all experienced this, but even just tracking that, just being able to lay out the dates. I called on this day, this day, this day. Over the course of a month, we got 0 calls back, or we got 1 call back at 8:15 in the morning. They left a message, no way to reach anyone. Whatever it is, just really sharing that kind of information adds up when we all do it. So I just want to encourage us all to kind of jump into that project as much as we can. And I think I will stop there. Oh, but I won't. I do want to also say, the separate issue, separate topic, is that along with National Consumer Law Center, National Housing Law Project has started up a listserv, and CLC manages that, and we are having bi-monthly calls on a national basis. So a lot of times about manufactured housing issues. A lot of times, because state law is so important for the rights of folks living in manufactured housing communities, usually people just sort of are a bit siloed in their different states. So we're trying to broaden the conversation. We've had a couple of these bi-monthly calls. We have this listserv that, you know, is getting more active. And if you do work with or expect that you may be seeing residents of manufactured housing communities. So these are folks who either own or rent the actual manufactured housing home or mobile home, as we call them sometimes, and live in a community or park where they are renting the lot. So that's their situation. They may own but rent at the same time. If you're working with folks in that situation, you may want to join the listserv. And then once you join the listserv, you will get all the updates about the bi-monthly calls. I think the next one will be, we're still working it out in July or August. And we would love to have you be part of that conversation. There are a lot of attorneys, legal aid folks, and some private attorneys who are part of it, but we already have some members who are housing counselors, and we'd love to have more. So I just want to invite you all to join if it's relevant to your work. And you can do that by using the link in the slides. And I think that's the last of what I'm saying. Is that right?
Yes, ma'am.
Okay.
Thank you. And I want to say thanks to all three of our panelists. I know lots of people talking in the chat about how much this has been useful to them and thanking you for it. I do want to say a little bit more about the link to tell your clients and your own stories. I mean, real personal stories have long played a role in changing how the public sees an issue. And a really clear example is the work of Lewis Hine, whose photographs of child labor helped build support for laws protecting children and eventually led to the Fair Labor Standards Act. His images, now in the Library of Congress, they show how sharing human stories can turn dry policy discussions into real change for real people. You are talking to real people on a daily basis. You're grassroots working with folks. So it's really important to go ahead and put as much as you can into this story gathering. This is our link. It's NHRC that will be managing it. So that's where the information will be held. So with that, I'm going to get to questions, but Alys, you popped on screen. I didn't know if there was something that you wanted to say right away, or you're just here for answering. Okay, great. So the first question I'm going to ask, is there any information or update on having medical collections removed from the credit report?
Yeah, I can take that one. So as folks know, in early January, before the change of administration, the CFPB issued a rule that prohibited medical debt on credit reports sent to lenders. And we all cheered that and we're very happy to see that, but knew that it would immediately come under attack by both industry and the new administration. And sure enough, the same day industry filed a lawsuit against the rule. Actually, two lawsuits were filed, one by the credit reporting industry, one by the debt collection industry. And then the change of administration happened. And so we at NCLC got ready and worked with two organizations, New Mexico Center on Law and Poverty and Zedek DC, and two individuals who have medical debt on their credit reports to prepare a motion to intervene in the lawsuit and ask the court to allow us to defend the rule. The rule was stayed by both courts for 90 days. And then at the end of April, the new CFPB under Russell Vogt filed a joint motion for a consent judgment. In other words, they agreed to give up and vacate the rule. And that's when the fact that we were trying to intervene became very important. The the industry actually said, okay, if you give us another stay until mid-July, we won't oppose your motion to intervene. And so that happened. The court granted our intervention. We've submitted a round of briefs. There's a hearing on June 11th in Plano, Texas, on this lawsuit. The judge has indicated that he might rule on the merits, i.e., conclude the whole litigation after that hearing. So we are expecting a decision after that. It's an uphill battle. I'm not going to sugarcoat it. We are in Texas. And so we are urging states to pass state versions of laws that prohibit medical debt on credit reports. There's 12 states that have done so already. Vermont and Washington State just passed their law, joining New York and Colorado, New Jersey, Vermont, Virginia, Minnesota, Illinois. But there are, another 38 plus states that can, and the District of Columbia and more, that can pass laws. We are urging states in passing these laws to include a couple of provisions dealing with the preventing lenders and landlords and employers from using medical debt on credit reports, and also requiring healthcare providers to prohibit debt collectors in their contracts with debt collectors from reporting it. And that is because those are safety nets in case there's a preemption challenge to the state laws, because there is a threat that the industry might try to claim the FCRA, the Fair Credit Reporting Act, preempts these state laws. So we're trying to build in some safeguards against that. And I'm going to put something in the chat, which is a piece on advice to state advocates trying to pass medical debt credit reporting bans.
So I guess a question that I have right away is, and I think somebody just put it in the chat. So is it right now, at this moment, can medical debt be on somebody's credit report?
So it depends on what state they're in. So yes,
Okay.
the rule has been stayed nationally. So on a federal level,
Okay.
medical debt can show up still on credit reports, unless it's one of the 12 states that have banned it. And you should not see medical debt that is under $500. Because you have the voluntary measures by the credit bureaus where they don't report paid, settled medical debt less than a year old, or medical debt under $500. So if you're seeing that, definitely file a dispute.
Okay, so back to servicing type questions. Does this mean that a servicer / investor can start foreclosure proceeding before the loan is 4 months behind?
So that question is related to, and Lisa knows at least as much about these topics as I do. So Lisa, you should feel free to chime in however you'd like. That question is about the fact that the current rules under RESPA say that you can't start a foreclosure before 120 days of delinquency. And so that's the 4 months. And so the answer is, if they withdraw that part of the rule, then yes, a servicer can start a foreclosure earlier. However, states have their own rules. And so if your state has a good rule on that, some states have 90 days, a few states have 120. It depends on whether you're in a judicial or non-judicial foreclosure state. Then they will be able to foreclose earlier. The other thing is, if the loan is a Fannie or a Freddie loan or an FHA loan, they currently have rules that mirror the Reg X rules. It's not totally clear to me that if they withdraw the Reg X rules, that the staff over there would follow suit quickly, because at the staff level, they probably know those rules exist and they probably want to keep them. And at the management level, they probably don't know they're there. So I think we just have to wait and see. That's just my personal observation. I don't know, Lisa, if you had anything you want to say about that.
Well, I just want to emphasize that the rule has not been withdrawn yet, that
Yes.
they're making a lot of noise, and it very well could happen. Nothing seems beyond the pale at this point. But right now, today, if somebody comes in and asks, like, I'm whatever, 65 days behind, what's the timeline? You can still depend on the 120-day rule in addition to whatever, your state's rules are. So I'm still holding fast to the fact that we still have it right now today.
Okay, I'm not sure what discrimination this is referring to, but I think it was asked while you were presenting, Alys. Would the newly created Office of Faith take on this discrimination and the unfair practices oversight?
So I'm not familiar with that Office of Faith. Maybe it's at HUD, based on my understanding of Secretary Turner's orientation. But the point isn't that one office has been dismantled, it's that the agencies and the administration are seeking to not have this work done at the federal level. And so it's not like it would be shifted from one place to another. And to just emphasize what Lisa's saying, anything that's against the law right now is still against the law, whether or not the agencies are enforcing it, whether or not they want to withdraw it in the future. It's all still there now, and it can be enforced by other folks. And that's why you need to build these relationships with your state enforcement folks.
Oh, and thanks, Chi-Chi, for putting that into the chat. In case people haven't noticed, Chi-Chi did list the 12 states that passed legislation prohibiting credit reporting on medical debts. Okay, I think that this did get addressed a little bit, but I think it's worth addressing again. I've been hesitant to send clients through to the CFPB. Do we know who is at the helm right now? And do you suggest it is business as usual and continue sending clients to CFPB? And I'm going to assume that that's to the complaint database.
Do you want to go first, Lisa, and I'll follow?
Yeah, I mean, I guess I would just say the idea of when we send people to the CFPB has never meant we're passing someone off or that they're going to have some, or we would expect that they would have some point person who's, taking up their case. It's always been a somewhat automated. I mean, someone's been looking at things, but really at the big picture level. So if you're concerned about, someone like who's sitting in the chair reading somebody's complaint, I guess currently I'm not that concerned about it because I don't think they're actually reading them. And also, what they really seem to intend to do is nothing. So I sort of point back to what I was saying before, which is I see the purpose now not as necessarily resolving the person's situation. And I would, manage expectations, like tell your client if you're asking them for their authorization or telling them they should submit, that this is the reason you're doing it. It's to create a record and be able to show at a time when someone at that level cares to look that these things were happening at this moment in time. So, I still think it's worthwhile, as you can tell, but I can understand, feeling differently. I'm not sure if I'm quite addressing what the concern is, but I don't know, Elise, if you want to say anything else about it.
I do want to say more about it. First, on this question of who's at the helm, I would say people who are zealously in support of whatever the White House wants are in charge. With regard to the complaint system, yesterday I was at the Consumer Federation of America's Consumer Assembly, and there were several people there who either still work at the CFPB or no longer work at the CFPB, but mostly people who are still employed there, and are technically working, although they don't have very much to do. And one of them specifically came up to me and said, "Thank you for saying in your remarks that people should submit complaints to the CFPB." This is someone who's pretty senior in a particular office there, although I will not say which one. And he said, "We look at those where we're using those. It's important for us to keep getting those." And so if we want to keep having a CFPB, then it's important for them to have that information. As Lisa said, there's no harm in doing that, but there's also not going to be any help coming to your client, and we recognize it takes time. And so you'll also want to file a complaint at the state or local level and still do everything you can for your client.
So I will say somebody just popped into the chat. I recently sent a complaint into CFPB on a reverse mortgage situation and did receive a response and movement on the loan issue, ultimately resolving the issue within a 45-day time frame. So that's encouraging.
Great.
So for
Frosting.
right. Yeah. Yeah. So I would say it's still worth it for a bunch of different reasons to go ahead and get those complaints submitted. Okay. Does the recent
Ellie,
Supreme
can I just say,
Sure.
Tiffany, thank you for telling us that, because we've been hearing that there, several thousand complaints behind, and it's hard for us to know what's happening. So it's useful to know somebody's being helped, because that's also a it's legally required to have a complaint system. So it's actually helpful to know that that's happening.
And would it be useful, Elise and Lisa, for housing counselors to let you know their experiences with the complaint database? Okay, well, they're both shaking their head. Yes. So the answer to that is yes. And I did earlier pop their email addresses into the chat, and they'll also be in the email that we send out to everybody following this with the recording. Everybody's
That's
contact
also a
information.
valid thing to report, I think, into your story system. Just,
Oh yeah.
we sent in, nothing happened. We sent in, we got a resolution in 45 days. And Ellie, you and I can talk about this more, but it's occurring to me, just as we're having this conversation, that a topic that might be really good for one of these sessions is just to spend some time talking about, how to put together these complaints. I mean, Chi gave you some really great pointers for the credit reporting ones, but I think there is a way to do them more and less effectively, and usually shorter and more to the point is better than telling kind of the whole sordid story. So that might be something we want to spend some time on.
So if folks on this webinar have an interest in something like that, just let me know. You can let me know in the chat, or you can just email me directly, epepper@hsgcenter.org, and we'll look at that. Thanks. Okay. Does the recent Supreme Court ruling on the president's ability to fire federal NLRB employees without cause affect the CFPB litigation?
Well, no one else is jumping in but Chi or Lisa. If you have a view about this, feel free to share. But so there was this decision on the so-called shadow docket that allowed for the firing of Democratic National Labor Relations Board commissioners, which is viewed as a takedown of this 90-year-old court decision called Humphrey's Executor, which says that independent agencies are exactly that, they're independent. The CFPB, because of other litigation, is not considered an independent agency. And so in that way, it's not directly affected. But I think the wise question sort of gets to this broader point, which is that the Trump administration is moving towards this sort of unitary executive situation where they're just going to rule with an iron fist. I don't know if people have more they want to say about that.
The only thing I would add, and sorry, I was a little distracted, so if you said this, I apologize, is that there was already a previous ruling with respect to the CFPB itself. Originally, when the CFPB was created, the president could only fire the CFPB director for cause, so they had to have actually done something wrong. And that was challenged, and there was lots of litigation. And a few years ago, we did get a ruling by the Supreme Court that said, actually, the president can fire the CFPB director, which is why we've seen changes in that role over the past couple administrations. So in a way, that issue of the president's sort of power to change the leadership at the agency had already been decided.
Okay, well, that's the end of our questions, except for one about, will there be a recording? Everybody should have access to our YouTube channel. And you can see all of our past webinars. And Miss Ivy, if you would pop our YouTube channel link into the chat again, you'll be able to see the recording of this webinar sometime early next week. And with that, I am going to go ahead and hand it back to Bruce to wrap us up and just say once again, thank you so much to our panelists for this amazing webinar and answering questions. I think everybody is really happy to have gotten this information. And Bruce.
Well, thank you, everybody. That was wonderfully detailed and helpful for, I think, the counselors in the field, and you got some very nice shout outs on it as well. So thanks for doing that. We will continue our series.